required, and if you don't have all the evidence, you can start working towards that. One of the things that you need to do is you have to show that you have awards and prizes for outstanding achievement in that field that you're applying for. You also have to show membership in an association that requires, that you demonstrate an outstanding achievement in that field as well. Another requirement is that you have to have published materials. It can be in an academic journal or it can be in a professional publication, and people have to acknowledge that you are an expert in that field or that you are so unique in what you do that you're recognized for that work. Now, another form or another piece of evidence that you need is that you must have been a panelist of some sort, or some people have referred to your work in their work or journals to do that. And lastly, the two other things that you could also show that you are qualified or an exceptional researcher is that you have original scientific contributions in your field, or that you've written a book, or somebody's used your work to write a book, or etc. Now the other one, which is
Bhora. I would like personally to thank her because I've been personally communicating with her on different levels before starting my residency and going through the J1 process, and she's always been very kind enough to respond to my queries. And I think most of our people who have been through the process through H1 and J1 knows Tony and Naeem very well. So thank you.
Good afternoon, everyone. I'm going to run through this really quickly because I actually don't know how many of the people in our audience are foreign nationals, but this is just at the very beginning of your career when you are applying for residency, and you also need to think about the visa side of it. I'm just going to run through the different visa options that are applicable to physicians, and also how to go about obtaining that visa. The most common visas for the physicians are the J and the H, which we are going to go through in a little bit more detail. But just wanted to also mention the O1, which is for people with extraordinary ability. Very similar to the category that Marina was talking about. You have to have a sizable publication, and this might be something to do later on in your career when you've finished some of your research or your fellowship and you're actually J1 subject. That might be a path for you. The TN is limited to Canadians and Mexican nationals, so if you're a Canadian citizen, this might be an option for you as well. But a word of caution, it's not for clinical, it's only for research or teaching. And then the E3, if anyone here is Australian, this is a perfect visa option because you can actually do residency on the E3, or if you're J1 subject, you can go through the E3 visa process without having to think about your J1 2-year residence requirement. All right, jumping into the J1, this is the most common visa for GMEs, or your residency program. This is actually sponsored through ECFMG, so they're the agency that's going to be issuing you your DS 2019. This is the underlying document to get your J1 visa. You do need to have steps 1 and 2 completed, and then also get the statement of need from your home country. You don't actually have to have any form of approval from immigration. Once ECFMG issues you the DS 2019, you can go straight to the consulate in your home country, get your visa, and then come in. The great thing about the J1, actually one of the few great things, is that the spouse can actually get work authorization. So we often see couples where one principal applicant's on a J1, start residency, and then his spouse gets his or her work authorization card, does residency on that one. Just a word of caution, timing can be a little bit tricky because if the principal applicant has finished his or her training and is transitioning, then the J2, who's also doing his or her training, needs to finish before or at the same time. Otherwise, there would be an interruption in work authorization. The big issue with the J1 is the 2-year home residence requirement, which is referred to as Section 212E, and we'll go into that a little bit detailed. 214B is where when you apply for your visa at the U.S. consulate, the consul officer wants to hear that you have a lot of ties to your home country and that you're going to go back home. So this is one of the main issues that we see when people apply for their visas, that they have to convince the consular officer that they really are going to go back home when they finish their training. They have no desire to live in the United States on a permanent basis. Another thing to keep in mind with the J1 is that they want to see progressive training. So if you match into a first 1-year preliminary position and then you aren't able to transition to a categorical position after that, and you get another 1-year prelim position, you might have a hard time getting ECF&G to support you on your J1. And we do see people getting stuck on that, where they can't actually demonstrate the progression in their training, and then they can't really move forward. So just keep that in mind. If you're also going to go through a longer track of training, one of the surgery tracks that take 8 or 9 years, it is possible to go get your extension beyond the 7-year limit, but you do have to show there's exceptional need in your home country for that training. Timing issues is also a problem with J1s. There is no premium processing, which is the fast-track processing with immigration. If you are applying for a change of status within the United States, it can take a good 4 or 5 months for the application to be granted. What this all means is that if you are matching in March, by the time you get your document for your visa, the DS 2019, it's now end of April, and then you really have about 6 weeks to get your visa issued at the consulate or get immigration to change your status within the U.S. So timing isn't a factor, so it might be easier just to go home and get your visa issued. You can also get J1 for research. The panelists before us were talking about that transition year to fill it with research, and you can absolutely do that. The institution, the medical center, would be the sponsor of the J1. Just to keep in mind that if you're from a country where there's a shortage of skills, such as India, for example, then you could be subject to that 2-year home residence requirement. Pakistan is not on the skills list, so that's fine, and you don't have to worry about that. But if you have any kind of government funding, such as a Fulbright or any government aid from your country, or a grant, then you would be subject to that 2-year home residence requirement. You can also transition from a J1 research to an H1B if you're not subject to any 2-year residence requirement. All right, now, for this whole concept of the 2-year residence requirement basically means that you can't get a green card if you have this residence requirement. And this is in place even if you're married to a U.S. citizen. Often people are really amazed that they have a U.S. citizen child and spouse, and yet they still have to go home for 2 years. They can't get that green card. But you can get all these other work visas instead of that if you want to postpone it. Just to keep in mind, though, that if you are subject and then you do want to transition to one of these visa classifications, you can't actually apply for a change of status within the United States. You do have to go home, get a new visa, and come back. All right. Now, if you are subject, then you can fulfill this requirement by going home for 2 years. You can postpone it by getting a different visa classification, or you can apply for a waiver. If you are going to be going home, just keep in mind that this has to be in the country that's listed on your DS 2019. If during this process you become a Canadian citizen or you become a citizen in a different nationality, you do have to go back to your original country to fulfill it. And you can do this in aggregate, so if you plan to spend 2 months every year, then eventually you will have those 2 years in your home country. Just be careful to document every trip that you go home. Hold on to your boarding passes so that when you are convincing immigration that you have spent those 2 years in your home country, you have the evidence to support it. All right. Okay, the other most common way to take care of this 2-year residence requirement is to actually get a waiver from the the U.S. government, and the most common waiver is through an interested government agency within the U.S. And within that is the Conrad State 30 program. And this is where every state has 30 slots for people who have committed to working in an underserved area, also known as a HIPSA or an MUA, and you're committed to working there for 3 years. And most of these states set aside their 30 slots for people who do primary care, but it is possible for specialists to also get a waiver, but just keep in mind that there's only 5 if the state does support it, and most of the more popular states like California will only do it for primary care. Primary care also includes pediatrics and obstetrics and psychiatry. All right, you can also get the waiver through hardship to a U.S. citizen or a permanent resident, child, or spouse, or the persecution waiver. That's where, very similar to an asylum application, you show that you're appearing going back to your home country. All of these waivers just take care of that 2-year residence requirement. After you obtain this waiver, you still need to transition to the green card and then think about all the things that Marina had talked about in terms of how to get that green card, either through extraordinary ability, through a family relationship, or through perm labor certification through an employer. If you're going to commit to working in an underserved area for 5 years, you can get that national interest waiver as a physician. The H-1B is the most common work visa for all professions, and if you are doing a Conrad waiver or a different IGA waiver, this is the visa classification that you're going to transition to, and you'll have to be on that H-1 status for 3 years. The H's can be filed up to 6 months in advance, and you can transition from the J1 to an H1 if you're going from J1 research to H1 for your residency. The H1 is limited to, there are 65,000 new H1 visa numbers that are given in a fiscal year, and they've set aside an additional 20,000 for people who graduate in a master's program from a U.S. university. This means for people who are going through their residency on an H1, so if you're going to just do 3 years of internal medicine and you want to transition then to your H1B job as an attending, just keep in mind that you have not been counted towards the H1B cap when you are doing residency, because all of those teaching hospitals are considered cap exempt, and then you will need to think about how you're going to capture one of these limited 65,000 numbers. It may seem like a lot of numbers, but in fact, within the first week that USCIS starts accepting these applications, they receive over 200,000 applications within the first 5 days. And what that means is then they conduct a lottery to randomly select the 65,000. And so your chance of being selected in this lottery is about 30%. And these are also people who are applying 6 months prior to that start date, which would be October 1, the beginning of the fiscal year. So not only do you have to have the job lined up 6 months prior, but you are subject to this lottery, and your chance of being selected in the lottery are about 30%, so the odds aren't very good. If it's possible to go from residency to another medical center that is considered cap exempt, then that is the preferred, because then you're not subject to this H-1B cap. Also, if you're doing a Conrad waiver, then you're cap exempt, you don't need to worry about this, and you can transition in July from your residency or fellowship to the attending position. H's are done through the employer. They have to pay what's considered a prevailing wage determined by the Department of Labor. You do have to have the license in place before you apply, and if you're planning to do residency on an H, you also need step 3. As you can see, H's are very expensive, which is why a lot of medical centers prefer that you do your residency on a J instead of an H. Okay, now how to obtain status. If you're already in the U.S. on a tourist visa for your clinical observerships, or you're doing interviews and then you match and you want to just stay in the United States, you can actually change your status with the USCIS. but you have to make sure that there's no gap in your admission period. So if you've been admitted through June, then that's great. You can apply to change status, and your new status would start before your current one expires. But if you've only been admitted until April or May, then that won't work because there will be a gap from when your future status will start. You also cannot apply too quickly. If you come into the U.S. in March, you can't apply within 1 or 2 months for a change of status, because then there's a perception that you've had a preconceived intention to stay and work in the United States, and that's considered misrepresentation. You should also think about what this would mean in the future. If you do change status, eventually when you have to go back to the consulate to get a visa so that you can travel, the consular officers are often not very happy with you and can try and make your visa approval a little bit more difficult. The H's are filed with USCIS, and as part of that process, you can ask them to change your status. For the J1, when you receive your DS 2019 from the university or from ECFMG, there's a separate application called the I-539 application, and this one does take several months, so you need to budget your time accordingly. For consular processing, this basically means that you're going back to the U.S. embassy or consulate in your home country or in a third country to get a visa. And some security check issues that are relevant is the Condor. This is the one where predominantly men from Muslim countries get subject to. Right now, they're clearing within about 2 weeks, so just something to keep in mind when you're timing your visa application. The Mantis doesn't really apply to Pakistanis. It's mostly for Chinese and Indian nationals. The Donkey is the one that we actually have the most problem with. This is where there is a potential name match, and they're not going to clear your visa unless they know that you are not that bad person on the list. And this is the one that can take several weeks. It can take up to a year, and it requires a lot of follow-up with congressional assistance or APPNA to try and get this actually cleared. The other one is when there is an actual hit in the criminal information, the NCIC. That's the one where you actually have a DUI or some other. And as soon as you finish your interview, make sure that you contact the APPNA representative early with your passport information, your date of interview, and they will then follow up through their channels at the State Department and get these cleared. And in the last several years, most people have been cleared and able to start within the first week of July. PINs is another issue that can come up with H-1B visas, specifically where you have the petition's been approved, but there's a delay because State Department needs to independently verify that your petition is legitimate and has been approved by immigration, and that can lead to a 1-week delay. And these are just some issues to keep in mind. If you are here and you need to go back for another visa application, just think about historically if you've had issues in the past. There's a lot of practitioners will say that maybe it's just best to stay put in the U.S., finish all of your training, because there are horror stories of people going back and having their visas actually revoked or being subject to wrong security checks all of a sudden, and then that jeopardizes their contract. So with that, I'm actually going to finish and transition on to Asim. Then I think we'll take questions, right?
I must say that was a great talk, Naeem. I wish I had access to you Taimoor. I was an Aized, but yes, Taimoor, and I wish I had access to you 4 years back. Without wasting much time, we will go to our last, definitely not the least speaker. So please, Umar. Thank you. A big round of applause for us at Wasique.
Good afternoon, assalamu alaikum. Hope everyone's doing well. So I'm going to be talking about something a little different. This is after hopefully you've gotten your visa and you're ready to work in the United States. You should really be considering the prospect of negotiating your employment contract or agreement with your university once you have obtained a medical residency. It's a part of our culture as Pakistanis to negotiate and haggle. but this should come as natural to us to have a little give and take and not just accept the contract that the employer is throwing at us full throttle. So, just by way of background, I practice labor and employment law, and we represent primarily companies, but we also represent professionals like doctors in negotiating contracts and agreements. And I have represented doctors before in the negotiation of contracts. And today's talk is basically about trying to tell you about some of the key provisions you should look at when you're negotiating, and some negotiation tips as well that I'm going to provide you. So basically, I'm going to give you some free advice today, free of charge. So one of the most important things people look at is compensation when you're looking at your employment contract. So there's a number of ways that hospitals or practices will determine compensation. Of course, you got to see whether you're a full-time employee or a part-time employee. Usually you're given a rate per shift as opposed to an annual salary like in many other jobs. There's also the productivity factor. So there's a term called relative value units that's used in the medical profession, which is based on obviously level of time, skill, training, and intensity required to provide the service. The other items that you should really pay attention to is your call and coverage obligations. As physicians, you know better than me that you're going to have these call and coverage obligations, and then if you don't do them, it's going to affect your compensation. But you got to make sure that any call and coverage obligations are clearly delineated at the front end as opposed towards the end. Sometimes you also get a guaranteed payment amount in your contract. So, God forbid you lose your job in the first few months of employment, you can stipulate to receiving a set amount of funds before you are terminated with or without cause. So my negotiation tip here is basically, before you accept the salary, of course, compare your offer salary with the physicians who have similar skills and experience, basically people who are similarly situated to you in your particular region of the country, to ensure that you are getting the fair compensation that you deserve. Another really important part that you should look at as physicians and young medical residents, maybe not so much residents, but once you actually end the residency and become a member of a practice or hospital, is the bonuses provision of your contract. And most contracts will have those provisions as well. The three more important ones are the sign-on bonus, the performance bonus, and the discretionary bonus. Many times with the sign-on bonus, and sometimes with the other bonuses as well, you have what's known as clawback provisions. So in the instance where you're terminated with cause, let's say for example, the employer actually has the obligation to take back your bonus. And this is something that I suggest to clients that you should eliminate or at least mitigate at the front end. So you have preserved your right to retain, let's say for example, a significant sign-on bonus that will help you transition to your next employment in the unfortunate circumstance if you're terminated without cause. Other items that we all are used to in many of our jobs, but you're going to have to negotiate as well with your employer, just benefits and expenses. So most employers in this profession will offer you health insurance for yourself and your family, group life insurance policy, disability insurance, and of course malpractice insurance is very important. I'll get to that a little bit more later in this presentation. General 401k retirement plans are very standard in these employment contracts as well. Usually they should reimburse you for your licensing fees, your CME courses, which obviously are required as a professional. For participation in conferences like this, most good employers should reimburse your travel and lodging expenses, your board certification exams as well, any medical staffing dues, and like any employer, you should also be entitled to, they should also provide you rather, your PTO time, your vacation, your holidays, your sick days. Also, something you often see in this particular industry is the relocation expenses. So I had a particular situation recently with one of my friends that was reviewing his contract, and unfortunately his hospital was downsizing because of a merger, and they were trying to take away his relocation expenses. So as part of the negotiation of his severance, I said, you got to let him keep his relocation expenses. He's going to be out of work for X amount of time, and we were successful with that. So generally, I would suggest to clients that preserve your right to retain these relocation expenses. Usually they're in the neighborhood of around $15,000. You could have folks coming obviously from overseas, so that's considerably expensive. But even if you're moving from one part of the United States to another part, it could be in the thousands of dollars, particularly if you have a family and you have other expenses to consider. In terms of expense reimbursement, the general standard that most employers have is just has to be reasonable and necessary out-of-pocket expenses that were incurred in connection with your employment. So obviously if you're using the employer's time to go for, go out to a show or do something that's not related to your employment, that's not going to be reimbursed. That goes without saying. I mentioned earlier the call-in coverage provisions that you have as an obligation as your employment as a physician in most professions, in most contexts. The failure to participate in these provisions generally will impact the compensation. You generally don't have an option not to participate in call-in coverage. You have to pay your dues and do so. But just make sure at the front end of your contract that you see concrete and specified obligations. So you could limit the hospital, the practice's ability to just call you in at any time they want. Make sure that they're complying with the actual stipulated call-in coverage obligations that you've agreed to at the beginning. There's always a provision about particular duties that you'll be performing as a physician, and make sure that these duties are actually encompassed in the negotiations that you had with your employer. So you're never asked to go outside of the scope of those duties. If you're a surgeon, for example, they'll specify the amount of procedures you may do in a particular contract year, the number of procedures. You'll also have a supervisory structure, evaluations, the actual length of the work week. Oftentimes in your profession, you're going to have folks who work a full week and then be off the next week. So just make sure that there's no ambiguity about the stipulated duties that you've agreed to perform based on your professional credentials, and remove any obligations that were not actually contemplated in your employment negotiations with your employer. Make sure that whatever you're going to be doing is actually in writing. A lot of these contracts also allow you to do outside employment, or otherwise known as moonlighting. Usually it has to be done on your own time. Obviously an employer is not going to allow you to do that on their time. You often will have to be in the position of applying for your own malpractice insurance if you do want to engage in a practice after hours, so to speak. This usually will require written pre-approval, and it is always subject to the employer's discretion and may be revoked at any time. As a negotiation tip here, I suggest that your outside employment be encompassed within your employer's malpractice insurance policy, because most employers will not offer that privilege. It may be a tough sell, but it doesn't hurt to ask. And this is a very important part of any employment contract, and particularly for physicians. These are known generally as restrictive covenants, and these are the provisions that a lot of folks refer to as non-compete agreements or non-solicitation agreements. Let's just start with the non-compete. So non-compete is basically, it is what it says. Let's say, for example, you leave a practice, you have an obligation not to compete with your former employer for a specific period of time and in a particular geographic location. And this is all dependent on the state you're living in too. It varies by state law. And just to preface, obviously I practice law in the United States, so I can't speak for what the state of the law in this area is in Canada. I know we have attendees from all over North America at the conference, but in the United States it varies by state law, and the general standard usually is a court is not going to uphold it unless it's a reasonable restriction on your employment. Because if you really think about it, it really is a restriction of your right to start a business or engage in commerce. So most courts are not very favorable to these covenants, but they will uphold them, and they may even modify them as long as they're reasonable. And generally, the reasonableness is 1 to 2 years in duration for most states, and the geographic scope will vary by region. So if you're living in a rural area, your former employer is not going to want you to compete 20 to 25 miles from you, because that employer is probably servicing a 20 to 25 mile radius in a rural part of the state. But if you're in a dense urban area, of course, the geographic scope is going to be far more limited because you have more density of population and more patients who need to be serviced. The key, obviously, is it has to be reasonable. Another very important restrictive covenant is non-solicitation agreements, and this also it has to be reasonable, and it prevents employees or physicians, in your case, from soliciting patients, client facility contracts, staff members, basically stealing those folks from your current employer and taking to your new business. You're usually restricted during the duration of your employment, obviously, from doing that, and also usually a 1 to 2 year period, depending on what state you're in. And again, the enforceability of these agreements depend on state law. There's a lot of litigation when it comes to restrictive covenants. In the employment contracts arena, this is the area that has the most litigation. And oftentimes, if you do, for example, start a practice in violation of a covenant, it's not uncommon for an employer to go and try to get a preliminary injunction against you in court to prevent you from starting that practice immediately when he finds out. There's also confidentiality agreements that are standard in these employment contracts, and that is pretty intuitive. It basically says that any kind of the intellectual property or the trademarks of your employer can't be used or taken by you, and you agree that you're not going to use it for your own private gain. So the negotiation tip here for restrictive covenants that I'm providing you is make sure to limit the duration and scope as much as possible of the covenant, but be prepared to articulate a rationale. If you're in a rural versus urban area, for example, look at the population density in your area, the scarcity of the physicians and your specialization. These are all important things that a court will look at if you're challenging a restrictive covenant as being unreasonable. And ensure that your covenant always complies with the applicable state law that you're in. Oftentimes with these covenants, if you do violate them, there is a way out. Usually, and often what you see is the physician pays $100,000 and they're kind of free to go ahead and start their own competitive practice. So this is usually called the liquidated damages or buyout provision of a contract. It provides relief from any limits that are placed by a restricted covenant on your business or business ventures after leaving your former employer. You may waive this right to buyout if you are terminated without cause. The employer always has the right to offset these liquidated damages by compensation that is owed under the agreement. And the employer may still reserve the right to seek injunctive relief, even if you've paid the $100,000 basically to start your own practice. So my tip here is ensure that the right to buyout is not reserved for a certain category of physicians. Make sure that you have that privilege as well. Make clear that the employer cannot seek anything beyond the stipulated damages that are in the contract. So if they're saying, I can violate this restrictive covenant for $100,000, make sure that they don't say later that you owe me $200,000 before you do that. And demand a waiver of this particular provision if you are terminated without cause. And a termination without cause is basically the employer says, I don't need you anymore, you haven't done anything wrong or in violation of your medical ethics, but we don't need you for whatever reason. Usually it's an economic kind of reason. So the termination provision obviously is you're going to have to pay a very close look at when you're looking at your contracts. So most contracts are subject to a periodic renewal of 1-year term, typically, absent a termination. You can terminate, obviously, based on mutual consent if you have other kind of ventures that you want to pursue. There's usually a with cause and a without cause provision of termination in most employment contracts. The with cause termination provision, things like you lost your license, you committed a crime, things of that nature, you're incompetent in your professional practice. That needs to be reasonable, it has to be narrowly tailored. And you also have to be given an opportunity to cure it. Most good contracts that are written correctly provide you as a physician with a reasonable time to cure it. So you'll get a letter, for example, on March 1st saying that you violated X, Y, and Z. Then most provisions and most contracts should allow you 30 days to remediate that if possible. And if you do remediate, hopefully you won't get terminated from that practice or hospital. Without cause termination provisions do provide you with notice that you are going to be terminated, even if you haven't engaged in any wrongdoing. And usually they're in a span of 30 to 90 days. They may also include an acceleration provision, like the instance of my friend who I reviewed his contract. In that case, the hospital was closing down, so they accelerated this without cause provision. They were saying you're being terminated next week without cause for economic reasons and downsizing. So at the front end, if you have that leverage in the negotiations, you should seek exclusively a with cause termination clause for the first few months of employment. And that's important because you don't want to start a job after you've done your residency, completed your education, and that then they just terminate you without cause in a matter of weeks. You want to at least have the assurance of having a guaranteed job for at least 6 months or whatever you can negotiate. Arbitration clauses are, unfortunately, I guess from your perspective, as an employee, unfortunately, I would say, is a standard clause in every employment contract now. This is basically depriving your right of going to court if you feel like you have, if you have lost a privilege or right under an employment contract. Essentially, they're very broadly written, and any disagreement or dispute that arises in your employment relationship under a well-drafted arbitration clause will have to go to private arbitration, meaning that you can't sue your employer for something like discrimination or harassment, even in a federal court or in a state court if you agree to an arbitration clause. Most employers will not provide you with the job unless you usually consent to this arbitration clause, but at this early stage, you should at least try to limit this arbitration clause. It also depends on state law whether it will be enforced. If it's very broad, some states will enforce it, but some states will require specific language to allow you to enforce it. From the employee perspective, you want to have all your options open, so you don't want to be forced to go to private arbitration. Usually the employer is the one who pays for the arbitrator, and the arbitrator usually is going to, in many ways, I mean, the argument is they're going to favor the employer because they're providing them with the business of the arbitration. So the negotiation tip is pursue a very narrow arbitration clause. You can try to meet the employer halfway and waive the right to a jury trial, but don't waive your right to go to court if you want to. The other issue is arbitration can be very expensive as well. Filing fees can be thousands of dollars, whereas if you're going to court, you may just pay a $400 filing fee and then you go forward. And then usually as a plaintiff, you're going to be running on contingency, meaning you're not going to pay your lawyer until the case is over, years down the line. Malpractice insurance obviously goes without saying is very important for physicians. The main categories are the occurrence policies, which is what you should be pursuing as a physician. This is something that will protect you more than a claims-made policy. An occurrence policy will basically cover you for any incidents that occur during the coverage year, regardless of when a claim is filed. So let's say, for example, you were, you committed malpractice in 2015, and the claim was filed in 2018. Even though you don't have that insurance policy anymore, an occurrence policy will still cover you for that malpractice claim. And that's definitely preferred by you as a physician. The employer will prefer the claims-made policy, so that limits your claims to only the claims that are filed during the particular coverage year. So in that same example, you committed malpractice in 2015, but you don't have coverage in 2018, you're not going to be covered. Sometimes they provide a tail policy, which provides coverage after the malpractice insurance policy has terminated, in my example, in 2015. So I would try to negotiate in the contract to have a tail policy if the employer is insisting on the claims-made policy. And again, malpractice law and insurance law, it varies by state law, so check your own state for the specific provisions. And eventually, obviously, everyone has the hope of becoming an owner in the practice that they join. So some considerations for equity and ownership I have down here. You're obviously buying an interest in the assets of the entity, and sometimes the practice will give you a binding commitment, and sometimes a non-binding commitment. And it's usually called a letter of intent. And so at the outset of your employment, they may provide you with a commitment that, yes, you will become a shareholder or a member of this practice one day. Sometimes it's non-binding. Obviously, from the physician's perspective, if you do see a future in that practice, you'd like to negotiate a binding letter of commitment. Definitely review your practice's bylaws, the operating agreement. Most family practices are set up as an LLC or a PC. Sometimes you can do front-loaded buy-ins, which basically means that you pay up front for your share of the practice over time, and sometimes that's deducted from your salary on a pre-tax basis over the course of years. That way you don't have to submit a lump sum at the time you're trying to buy into the practice. The value of a basic, typical practice is based on the accounts receivable and the assets and book value. Book value is basically the amount of, the value of the equipment. So that's going to be really the nominal part of the practice. Where the real money is the accounts receivable, basically the amount of money that the practice is waiting from insurance companies and for various claims and services that it's rendered. So that's the amount, including these assets and book value, that's going to be equally distributed among the partners in the practice. Goodwill is kind of an old term, but it still exists. It basically is an economic valuation of the reputation of the practice and the patient list that you're inheriting if you're purchasing a practice. That's usually going to happen in a situation where you're inheriting a practice that's been around for decades in a particular community. So the negotiation tip here is ask for a letter of intent, a binding letter of intent at the outset of your employment in a practice, and request lower front-loaded buy-ins so it's more economically practical for you to actually become a shareholder one day. Now, and obviously I know there's a lot of folks applying for medical residencies here today, so here's some specific issues you should look out for medical residency agreements that you're going to start looking at hopefully once you get matched. So there's due process and grievance appeals procedures that exist in medical residency contracts, which don't really exist in the private employment contracts world. So in a situation where you're, God forbid, suspended or demoted in some capacity in your residency, there is actually a procedure for you to appeal that through various boards in the university. Make sure that you understand those procedures. make sure that you have all rights under those procedures, and that it's not just a nominal process for the university just to terminate you whenever they please. You're going to have to show your educational credentials, licensure, goes without saying, to actually be part of that residency. The frequency of the call and coverage obligations you're going to have as a resident, this kind of is different from work once you're actually graduated from your residency. From what I've seen is that how junior you are will determine how much call and coverage obligations you're going to have. So obviously residents complain about how long their work hours are. So a first year resident may have call and coverage obligations every 4th night, whereas a second year resident may have it every 5th night, and a third year, once you're senior, you only have to do it every 6th night, for example. So as a negotiation tip, make sure that the due process and grievance and appeals procedures are clearly spelled out in the medical residency contract. So here are the key takeaways that you should just absorb as you walk away today, and once you're starting to negotiate your medical residency contract or employment contract. I'll obviously prioritize the provisions that I've discussed today, see what's important to you, set expectations. You're not going to have the most leverage coming in as a junior, physician in a practice, but don't let that dissuade you from actually negotiating and trying to get what you want from the situation. Gauge the context. Obviously, if the employer is not willing to negotiate much with you, absent a couple provisions, then don't push the envelope too far, because you want to keep that job, of course. Approach negotiations with the team mentality. Don't approach the negotiations from a position of hostility. Don't overreach, obviously. Try to negotiate things that you think are actually achievable, but never submit to the contract as offered. Almost everything is subject to negotiation. And this is going to be critically one of the most important economic decisions of your life, outside of probably applying for a mortgage. So you should take time, consult with an attorney. Don't just jump into a contract and accept everything that's being thrown at you. Economically, it makes a lot of sense to consult and engage an attorney to at least review your medical residency or employment contract. It's very difficult, if not impossible, to change the provisions that you've agreed to in your employment contract once you've already signed on the dotted line. So here's just a little background about our law firm. We practice across the United States. I work in New Jersey, but I'm licensed in New York and New Jersey. We have an incredibly large health law practice. We represent hospitals and physicians. I represent all kinds of hospitals and physicians as well as a labor and employment attorney. We obviously service the healthcare industry and as well as the life sciences industry. We have a number of blogs that you can look at that physicians may find of interest, like physician law, HIPAA, high tech and HIT, and employment discrimination and wage and hour report. We're also very active in social media. Here are our Twitter accounts, our Facebook page, and our podcast information. And this whole presentation I've left over there on the side. There's a hard copy there with my contact information, and I left some material about our different practices as well. And thank you very much.
Taimoor, let me ask you this. Have you signed your contract already? Work is in a time.
Yes.
So you missed that I made for, I just made it in time for this presentation so that when I sign my contract next year, I'll have access to all this knowledge. All right. So we're going to proceed with our question and answer sessions. If anybody has questions for them, please come over. Let us know. I can start with a question myself. All of you can answer it, but I think Naeem would be probably the best one. I've been asked this question multiple times. If somebody's doing a J1 research, like suppose for 2 years, and they're subjected to the 2-year home country requirement, if they're Indian, that's what I got from the talk, but not from if they're Pakistani. But then they get a residency, for example, let's say surgery or radiology, that's a 5-year residency. So that means 2 years of research and 5 years of residency, they're already at 7 years, right? So if they do a fellowship of 1 more year, that's going to be the 8th year. So is that cumulative, that the research period on J1 and the clinical period on J1? How does this work? Does that person, can that person do an extra year of fellowship without asking for an extension?
That's a really good question. My understanding is that the 7 years is for clinical, but this applicant really needs to talk to ECF&D from the beginning and understand what they would have to do and what their plan is, having already done 2 years as research. If they're J1 subject, they will have to go back home to get their J1 visa and then come back. You can certainly do the J1 clinical after that. Often though, transitioning from J1 research to J1 clinical, you do need to show there's a nexus from what you were doing as your research to what you're doing for clinical. So that is a State Department requirement. And then just let ECFMG know that you are planning to apply for a fellowship. You're going to be reaching your 8th year, and would they be supportive of that? So when you're applying.
So I've placed 2 sheets, one for the oral presenters. Yeah, those are for you. And so you're going to score like as a ranking fashion from 1 to 4 on the oral presenters. We have 4 oral presenters and 8 poster presenters. So we're going to start from our first oral presenter. You can take our resident Muhammad Zishan.
Hi, good afternoon, everyone. Thank you so much for giving me the opportunity. So, first of all, a brief introduction of me. My name is Muhammad Zishan. I'm a third-year psychiatry resident at Mount Lebanon Hospital. I was born, just a brief collage about me, I was born and raised in Sham. And I went to Nishta Medical College, graduated in 2007. So, before going to medical school, so I worked with my father in a restaurant for almost 12 years. So I was always curious why Allah wanted me to work in a restaurant before going to medical school, and I didn't get the answer till I got married, because one of the best things that my wife liked about me is the fact that I cook good food. So, and just to clarify before clapping that this is not the only reason we are together for 3 years. And we recently have a daughter, Minal Fatma. She is 4 months old. So moving forward, so first of all, this is a team effort. So this is who we are. Dr. Sadiq Naeem is an attending child psychiatrist at University of Kansas. Dr. Nusrat Jahan and Anas Tariq. So they are research assistant. Nusrat is in Mount Sinai, Chicago, and Anas is in sunny upstate. So this is a team effort. I am just getting an honor to present it, but we all work together to compile, to work on it. So first of all, the objective of our presentation. So there are 3 main objectives. So first is to get to know different type of reviews. The other is to provide tips and strategies to how and when to employ different research strategies. And the third, to encourage the new researcher, because that's what I realized is the audience, to encourage new researchers to use an objective and transparent approach to avoid the bias. So outline, so my presentation, so first I would like to describe about different research reviews, then how to perform systematic review, how to formulate a research question, and how to do a research literature search. So I would like to start with some definition. So there are 3 types of reviews. One is a systematic review. So systematic review is the review based on a clearly formulated question. Then is the meta-analysis. Meta-analysis is basically the review that done by a statistical analysis to combine the study to come up with the result. Then is a narrative review. So narrative review is an informal and unsystematic and subjective method. So I would just give a brief example of the narrative review, and then I will describe about the systematic review in the later slide. So narrative review is just like that. Like I saw a patient with a major depressive disorder who was taking SSRI, got some side effect. So I would just go into PubMed and just put depression, SSRI side effect and get some data, summarize it. So that's a kind of narrative review. And in the next slide, I would elaborate on what is it, how it is different from the systematic review. So couple of 2 or 3 slides about the bias, because doing a systematic review, one of the main objective is to avoid bias. So selection bias is related to the type of research studies we chose that were not presenting the question, like we chose a sample size that was not actually presenting the population. The performance bias and detection bias is related to the researcher knowing that who is getting the intervention and who is the control. So performance bias is related to giving more attention to the people who, to the patient population as compared to control, and detection bias is to do the results more carefully with the people who are getting intervention. Attrition bias is because of someone lost in the study, and reporting bias is just focusing on the published data and ignoring the unpublished data. So the next couple of slides, I would like to go step by step how to do a systematic review, and you will realize that how it is different from a narrative review, and why we are so emphasizing to do a systematic review, and why it is very important and very valuable in the research. So there are a couple of steps. First, and the most important step, which we usually don't give much time and we should have, is the formulating a research question. Then the research protocol registration, the literature search, how to do a literature, how to extract the data, and interpretation of results. I will elaborate each slide in the next. So first of all, how to formulate a question. There are a couple of tools. One is the PICO, P-I-C-O. So P stands for population, I for intervention, C for comparison, O for outcome. And I will give you an example how we can use this tool to get a formulated question. So this is I'm a psychiatrist, I will give you that example. So a 50-year-old female who was diagnosed with moderate depression. She was getting a Celexa, citalopram, got some side effect, heard from one of friend about St. John's wort, and so she came to clinic this time and asked for her psychiatrist that can she try a St. John's wort to avoid the side effects. So that's a scenario, and we wanted to do a systematic review. So how we will use this model. So PICO, so population. So this is in this case is a 50-year-old female with moderate depression. Intervention was St. John's wort. Control is citalopram, and outcome is depressive symptom and side effect. So one other thing which I want to mention in this, the good thing about systematic review is that you give a very focused information. In population, you are not just mentioning the 50-year-old, you are not just mentioning the female. It's a 50-year-old female with moderate major depressive disorder. Because to get a good data set, you need to be very focused. So for this example, particular example, so the research question would be, for a 50-year-old female with a moderate depression, what is the efficacy and tolerability of St. John's wort as compared to the citalopram? These are some other tools. I won't go in detail. So there are SPICE, SPIDER, and Epilepsy. These are also the research question tools. So there are different type of research questions. One I told was earlier mentioned about the effectiveness. There are other about incidence prevalence. There are some about prognostic and diagnostic questions. So another thing why we need to formulate a good research question is to realize the importance of broad versus narrow questions. So the broad question, like in the previous examples, the broad question would be, does psychotherapy work in the treatment of psychiatric disorder? So one of the disadvantages that you won't be able to get result at the end if you do a very broad question search. And the narrow-ended question, like in that example, the narrow question was, is St. John's wort effective in treating moderate depression in patients with 50 to 60-year-old? So the disadvantage would be that you would miss a lot of important data, and you won't, if you come up with a conclusion that won't apply or won't be generalized to the other population. So those are the slides about how to formulate a question. So the next slide I would elaborate on registration protocol and why it is very important, because you want to register for a research protocol to see that there is nothing done before to avoid any duplication. So this is a PRISMA P. PRISMA stands for Preferred Reporting Items for Systematic Review and Meta-Analysis Protocol, and there are certain things that they want you to mention when you are registering, when you are sending for a protocol. So you need to mention about the title and then register to Prospero and Cochrane 14 database systematic review to check that the this question was not done before. And then describe the objective, and in objective you will elaborate more on the research question about PICO people. Then the author, contribution and financial institution, if you need to disclose it in detail. And then mention about the introduction. So in introduction you will elaborate about the objective, like why this question, why you want to do systematic review in this question, what is already known and what you want to elaborate. And then explicitly about people. So in Prisma B there is another thing, is about the method. So what thing when you are sending a protocol, what thing you have to mention in the method part is the research question, your study design, the setting, either it was done in the outpatient or inpatient, time frame, and what are the information source. In next slide I will tell about the information sources too. And then what are the selection and data collection process. It is highly recommended to have 2 independent research reviewers who go through with all the studies that you screen to avoid any duplication. And then the outcome and prioritization. We need to elaborate in the protocol that what are our primary outcome, what are our secondary outcome, and if we notice any bias in our research methodology. So we need to mention beforehand in our research protocol. So those are the slides about the registration. The next slide, this is the third steps in the systematic review. So this slide will show how to conduct a literature search, because you formulated a question, you write down your research protocol. So now how to do a literature search. So there are 2 or 3 resources. Medline usually focused on the American literature. Embase is European, and the hand searching is just to search about the unpublished data. And the other thing, how to come up with a good keywords for your research question, because it's very important to use proper keywords. So there are Google Scholar and Scopus, so you can go and find out a good research question, keywords for your research question. And then how to limit, because you don't want to put the keywords and get so many studies that have that keyword. So how to limit your search. So there are 3 keywords that you can use in your key search. It's and, or not. So you can combine your keywords with this combination. Then how to do a finalization of search. So first of all, as I already mentioned, there should be 2 independent reviewers of the research. So they will remove the duplicate search. Then there are 2-stage screening. In first stage screening, what you would do, so you formulate a question, you send the registration protocol, you use the appropriate keyword, and you come up with some studies. So, and then you remove the duplicates. So the next process would be that both reviewers will review the title and abstract, and then in the second stage screening, review of the complete article. So the goal would be to include only those studies, those are very relevant, those follow your inclusion and exclusion criteria. So you did all those steps, you came up with the study. So what you need to do when you are reviewing a study, what you need, how to extract the data, what are the important things you are looking from each individual study. So first of all, references. What was the objective of the study? What is the study design? And what was the population? Like what kind of demographics of the participant in the study? And then intervention, description of the intervention. What were the medication used? What were the control and the outcome? What were the outcome of the study? And the comments about detail regarding the study quality. So after that, you need to do the interpretation of result. So in interpretation, you will come out, like maybe after all this, you will come out is it a significant conclusion, or you were unable to conclude anything? Then you can mention about things that why you were unable to do and what need to be done in the search. So those are my presentation. So if you have any question, I would be more than happy to answer. Yeah. I mean, it's my expression, that's true. But that was at the time when I was presenting first time.